Obunkenke ku kkooti ng'omukulu litaali Dr. Kotte Besigye ate ne pulezidenti wa kuno His Excellency Kyagulanyi Ssentamu Robert Bobi bonna nno bali ku kkooti ng'era bano bagezaako okuwakanya ekyo gavumenti kyano kyekola eky'okukwata ba civilian ne bateeka mu kkooti z'amagye, ekintu pulezidenti Kyagulanyi Ssentamu Robert Bobi kyawakanya era kyawakanyizibwa ddala. Twongera bategeeza n'okubajjukiza nti omukulu Yosayiti Bukabulwa agenze mu maaso n'okukaka abantu bannamagye okubeera nga be bawozesa ate ba civilian, ekintu ne kkooti enkulu kyegamba nti nedda. N'olwokuba nti bano bamanyiira okutumanyiira, bamanyiira okutulinnyako, bamanyiira okumanya nti bannayuganda tebalina kyakukola, tebalina kyakuzzaako, tukole nga bwe twagala. Era bo bibayitako biyisi bibayita ku maaso naye nga His Excellency alwana okulaba nga mukwano gwe, muganda we, kyaliwe mu byobufuzi omukulu litaali Dr. Kotte Besigye ate nga anunulwa. Tuli wano mu Supreme Court.
Of the Constitution. However, it is an overreach to have been contravened. Please note that the sections of the law I will be quoting are quoted from the immediate past laws of Uganda volumes and also from the most recently published edition. So in my final judgment, you will find two versions of laws. When I read them, I'll read the one that was probably cited during the hearing. I would allow this appeal in part. The Attorney General lodged an appeal against the decision of the Constitutional Court dated 1st July 2021. The respondent had challenged the competence of the General Court Martial to try civilians under the Uganda People's Defence Forces Act, alleging that the continuance of these trials violates constitutional provisions, including Articles 28(1), 44C, and 210 of the Constitution of the Republic of Uganda. The Constitutional Court, being the court of first instance in constitutional matters, heard the petition and decided that the General Court Martial is a constitutionally established court set up to handle cases of military discipline for the UPDF members, but lacks jurisdiction to try civilians for offenses under the Penal Code or other enactments. As a result, Sections 2, which now reads as Section 1, Sections 1191H, and Section 179 of the UPDF Act, which expand military jurisdiction of the courts martial to include civilians and classifies civil offenses as service offenses, were declared unconstitutional for violating fair trial guarantees and exceeding the mandate under Article 210B of the Constitution. Finally, the court found that Section 119 is not unconstitutional, provided the person not otherwise subject to military law is tried as an accomplice together with a person who is subject to military law as the principal offender on the same charge sheet. I am abundantly aware of the tension that exists between ensuring unfettered military discipline and compliance with the tenets of constitutional right to a fair trial, which should be available to all human beings, including men and women who serve in the military. This entails a delicate balance on a constitutional landscape which the courts are obligated to navigate. I have, in my judgment, undertaken a synopsis of the historical evolution of courts martial in order to locate their relevance and effect in our current systems. In this regard, I have considered the era of the Romans. While the Roman Empire is often considered one of the most influential and impactful empires in history, most historians would not consider it to have been the greatest empire in terms of sheer size. However, the Romans are credited with codifying and maintaining accurate records. The Roman Empire's legacy of military discipline is notable for its extreme punishments, such as dissemination, where 1 in 10 soldiers were executed for collective disobedience. Collective disobedience included such offenses as mutiny, and mutiny included offenses like tree-sitting, sabotage, among others. Tree-sitting meant that the rank and file of men in the mutiny would choose to sit under a tree and not do any work. Annihilation was the extreme measure historically used to enforce discipline in the rank and file of the Roman army. In the latter years, the Normans emerged following the Romans. The Normans, or the Normandy, introduced trial by combat to settle disagreements over money or chattels, movable or immovable, including land. Participants engaged in physical combat until one was killed or 2 wounded to continue. The loser was hanged, reflecting the belief that God had found them guilty. This particular practice of combat was outlawed in the 19th century, with survivors being charged and tried for criminal offenses. One of the Normandy kings, William the Conqueror, developed military justice and influenced feudal traditions in the United Kingdom, including duels and, again, trial by combat. The duel significantly influenced modern culture. The duel was, just like the combat, a situation where 2 persons who had a conflict fought it out physically. The duel in our modern days is the equivalent of the adversarial system in the court, where lawyers for and against parties do battle. The lawyer's sword today in court is his spoken word. It is a duel of words, but it was a duel in the Norman days. The shire courts were introduced by William the Conqueror and maintained by him. These were courts made up of clergy and local leaders who sat and decided cases and received alms from their salaries. That also explains the lawyers' dressing today. It came from the shire courts. Under William the Conqueror, the principle of resolving disputes within the military hierarchy persisted and influenced courts martial. We'll then go to King Gustavus Adolphus. King Gustavus Adolphus of Sweden formalized military justice with his 167 articles of war, introducing regimental and standing courts martial to enforce discipline and morality. These systems were credited with fairness and morality, and hence influenced both Europe and the British military laws. And up to date, there are military academy known as the Gustavus Academy. The Soviet Union. The Soviet Union discipline of its rank and file was enforced through punishments, awards, incentives, and enhanced patriotic zeal. Severe discipline was demanded by Lenin and Stalin to effectively use modern war implements like tanks and airplanes. The punishments in the Soviet Union included drinking restrictions, surveillance, counter-surveillance, and even physical searches. One of the most notorious infractions a Soviet soldier could commit was drunkenness. The persistent inspection and searches of the soldier military personnel frequently made it difficult to smuggle alcohol into their garrisons and posts. A non-fiction writer identified alcohol as the primary cause of disciplinary infractions in the Soviet armed forces, resulting not only in drunkenness, but also in theft, bribery, record falsification, and deliberate damage. Alcohol was used not only to deaden the senses and allow a period of escape from the hardships and pressures of daily life, but was also used to celebrate and commemorate every event. Soviet soldiers and sailors were supposedly only permitted to drink when expressly allowed in accordance with the regulations. The Soviet soldier drank when the opportunity to drink presented itself, in direct violation of disciplinary restrictions. They were so starved of drinking that they resorted to drinking the eau de cologne, eating shoe polish when vodka was unavailable. This infraction, though minor, could lead to severe punishment, including imprisonment or banishment to Siberia. The British military system, originating from the medieval court of the chivalry, involved tribunals. The decline of the court of chivalry led to councils of war, which addressed offenses such as mutiny and desertion. They enacted the Mutiny Act of 1789, which established a legal framework for the courts-martial, ensuring discipline while introducing procedural safeguards. Key issues included the struggle for control over the military justice system and the development of military due processes. The American military justice system originated during the Revolutionary War, drawing heavily from the British military codes. Post-World War II dissatisfaction with the wartime military justice led many Western countries to adopt more judicial approaches and procedures in their military justice. The American military justice has often seen the intervention of the US Supreme Court in military matters. The question of the status of the offender are constantly under review. A status of the offender determination by the courts helps in restricting which offender is liable to appear and be tried before a court-martial. Often, the spouse or dependent of a serving officer and a civilian worker connected to the military either lose or have their day in court when found offending. The cases of Milligan or Callaghan, Kinsella, and Curry are but a few examples of judicial review of military justice. The determination of what amounts to peacetime and wartime offenses are interrogated by the civilian courts. Uganda's military justice system. Uganda's military justice system was influenced by the British military law, partly because we were colonized by that country. Fast forward, the 1975 Economic Crimes Tribunal, established by the government of the day between 1971 and 79, was established to punish profiteers, hoarders, and others acting against the state's economic interests with penalties including death by firing squad or imprisonment. During the period 1971 to 1979, military tribunals often tried civilians and soldiers alike with little regard for fairness or due process. The system was highly politicized, with military tribunals taking precedence over the civil courts. In its military institutional framework, Uganda borrows heavily from the British, the American, and indeed the Soviet or former Soviet states militaries. We have offices such as the judge advocate and the political commissar, which are vestiges of our non-aligned associations with those countries. I will now move to the matters at hand. Notably, the provisions in Section 119 are at odds with the constitutional guarantees under Chapter 4 and 8 of the Constitution of the Republic of Uganda. The current status of courts-martial in Uganda is that all officers who sit on the General Court-Martial are serving army officers who are appointed by the High Command and are men under authority at all times. This means that the setup of the military courts does not follow a process that gives assurances that they will be independent and will deliver justice without fear or favor. By the very nature of their appointment, the structure and the reporting lines, courts-martial are firmly under the superior command and possible instruction of their bosses. Articles 21 and 28 of the Constitution, which provide for equality before the law and a fair trial, offers the following guarantees. The guarantee for equality. Equality means that all persons who appear before a tribunal or court of law are treated equally regardless of their race, their gender, age, or other factors. Presumption of innocence. That an accused is presumed innocent until proven guilty. Burden of proof. That the prosecution must prove its case beyond reasonable doubt. An independent and impartial tribunal. The trial must be conducted by an independent and impartial tribunal. Opportunity to present evidence. The accused is granted the opportunity to present evidence and to challenge the prosecution's evidence through cross-examination. Right to an interpreter. That the accused has a right to an interpreter if they cannot understand the language being used in court. Protection from self-incrimination. That the accused has protection from being forced to incriminate themselves. Right to a public hearing. That the trial shall be open to the public. Right to be represented by a lawyer. That the accused has the right to be represented by a lawyer of her choice at all stages of the trial. I have found that the determination of the jurisdiction of the courts-martial attracts investigation of the legislative intent of creating it. And I ask the question, was it the intention of Parliament to vest the courts-martial with jurisdiction to try only serving officers for committing a service offense, or was it their intention to extend military jurisdiction to civilians? Reverting to the long title of the UPDF Act, it is clear that the application of the law was intended to be restrictive rather than general, as it specifically states that it is an act to regulate the Uganda People's Defense Forces. To this end, Section 197 of the UPDF Act also states clearly that there shall be a court-martial for defense forces. How does this stand with the Constitution? Article 44 of the Constitution provides 4 non-derogable rights. The safeguards given under Article 44 include protection from torture, cruel, inhuman, or degrading treatment or punishment. The second is a protection from slavery and servitude. The third is a right to a fair hearing. And finally, an entitlement to a writ of habeas corpus. Essentially, these 4 rights are established as non-derogable, meaning they cannot be taken away even in emergency situations. When juxtaposed against constitutional provisions, Sections 2, Sections 1191G and H, and Section 179 of the UPDF Act are found to be in contravention with Articles 28, 43, and 44 of the Constitution of the Republic of Uganda. The jurisdiction of the courts-martial is properly vested where there is a demonstrable connection and causal link between the service offense alleged to have been committed and the status of the offender as an active duty and image bearer of the armed forces. The status of the accused is pertinent in establishing the jurisdiction of military courts over civilians. It cannot be overstated that courts-martial present a viable means of implementing military justice in a practical, efficient, and flexible manner. We would borrow from other jurisdictions which make a proposition that national defense mandates an armed force whose discipline and readiness are not unnecessarily undermined by the often deliberately cumbersome concepts of civilian jurisprudence. Yet the dictates of individual liberty clearly require a check on military authority in the conduct of courts-martial. The provisions of the American Unified Code of Military Justice with respect to court-martial proceedings represent a congressional attempt to accommodate the interests of justice on the one hand, with the demands for an efficient and well-disciplined military on the other hand. Indeed, the true test to be directed toward comparing courts-martial with contemporary civilian forums is not that we have improved from an epoch that was said to be unjust, but rather that we are comparing favorably with the current constitutional mandate. So when I talk about the historical evolution of the military justice, the idea is not to say that since things got better, but rather to say where do we stand today? The true test ought not to be that military justice today has a semblance of due process. Rather, the test should be whether the military courts-martial as it currently is living up to and can be held against the standards that offer protections for individuals against prosecution, detention, without trial, and do not permit any limitation of enjoyment of rights and freedoms beyond what is acceptable or demonstrably justifiable in a free and democratic society. I find that it is constitutional to create and have general court-martials. Historically, the purpose of the general court-martial was to instill and maintain discipline in the rank and file of the armed forces. To the extent that it exists to discipline and bring justice to its own rank and file, who are in conflict with its laws, its processes, and its procedures, the existence of the courts-martial cannot be questioned. Let me conclude on this note. Courts-martial are specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with the discipline and regulation of the armed forces. The Constituent Assembly, while debating the setup of the army courts back in 1992, envisaged military courts as special purpose vehicles to enforce discipline within the military and ensure that there was a battle-ready and disciplined force anytime they were needed. Leading up to the enactment of the 1995 Constitution, the CA did not support granting army jurisdiction over civilians. The Constituent Assembly laid emphasis on the necessity to guarantee a free and fair trial and other due process rights and critical need for the independence of the courts-martial, stressing that their role be limited to handling military-specific offenses against military personnel. The General Court-Martial, as currently set up under the UPDF Act, is fundamentally incompatible with the constitutional safeguards for a fair hearing and is unconstitutional, and therefore its exercise of judicial power is equally unconstitutional. To re-echo the words in Curry, the court-martial system structure, including the convening authority's power to prefer charges and select court-martial members and report back to superiors, is fundamentally at odds with the due process and constitutional in the civilian justice system and even unjustified in the military justice system. Having found as above, I hereby make the following declarations. Judicial power in Uganda is exercised by the courts of judicature and such subordinate courts as Parliament may by law establish. The court-martial system established under Section 197 of the UPDF Act is therefore one such subordinate court. I would declare that Section 197 of the UPDF Act, which establishes the General Court-Martial, is not in breach of the Constitution. However, it is an overreach when the UPDF Act creates an offense that targets persons not otherwise subject to military law, making them criminally liable before the court-martials for offenses of aiding and abetting. For creating such vulnerability, I would declare Section 117, which it is now, and Section 1171A